Attorney P.J. Hartman in Albuquerque, New Mexico. Learn more about child custody and support laws in this video. What are the differences between legal custody, physical custody, and visitation? Parents with legal custody are responsible for making all decisions impacting a child, from what school they attend to what doctors they see. Physical custody, on the other hand, consists solely of where the child lives. Both legal and physical custody may be sole or joint. For example, the child may spend time living with both parents, but have only one parent in charge of making decisions for them. This would be joint physical custody with sole legal custody. Conversely, the child may live full-time with one parent while both parents share responsibility for decision-making, sole physical custody with joint legal custody. If one parent has sole physical custody, then the other parent will often be awarded visitation. The terms of visitation depend on the specific circumstances of the case. In this type of arrangement, the parent with physical custody is known as the custodial parent, while the other parent is called the non-custodial parent. Parents can work out their own visitation agreements, but if they are unable to agree, the court can issue a visitation order. If one parent may be a danger to the child or has never developed their relationship with the child, then the court may order supervised visitation. In New Mexico, this is done through a program called Safe Exchange and Supervised Visitation, or SESV. In SESV, both parents and the child meet at a safe, neutral, court-approved location. How is child custody determined? The primary factor guiding custody decisions is the best interests of the child. Since it is beneficial to a child to have a relationship with both their parents, the court will begin with the assumption that joint custody will be awarded. However, if there is evidence that one parent may be unfit to raise the child, the court may award sole custody to the other parent. There are numerous factors the court will consider while evaluating what is in the best interests of the child, including the child's wishes, if they are 14 or older, the mental and physical health of the parents, the desire of the parents to have a role in raising their child, stability of the child's environment, the child's education and health care, custody of siblings, if any, presence of extended family and support structure, such as grandparents, evidence of drug or alcohol abuse, or a history of domestic violence or child abuse. The goal of the court is to gather as much information as possible about the child and the family and come to a decision that gives the child the best chance at a safe, healthy, happy life. The document that regulates child custody is called a parenting plan. The parenting plan is an agreement between parents. However, the court will review the document to ensure the arrangements are in the best interests of the child. How are child custody agreements changed? The first thing to keep in mind about modifying a parenting plan is that the courts want the child to have as much stability in their life as possible. For this reason, the court will only consider modifying custody arrangements if the arrangements have been in place for a year or more. The exception to this rule is if the safety of the child is threatened by the current arrangement. Likewise, the court will not allow modifications to child custody without an important reason, known as a substantial and material change in circumstances. What constitutes a material change in circumstances can be a bit vague, but there are some things that the courts will almost always consider a material change. One parent moving, especially to another city or state, one parent moving in with someone, particularly if that person has a criminal record, the child turning 14 and expressing a desire to change the custody arrangement, a significant change in the child's life, like starting school, one parent refusing to obey the established custody agreement, or one parent being charged with abuse. If both parents can agree to the modified terms of the agreement, the court agrees there has been a material change in circumstances, and the new agreement is in the best interest of the child, then the court will approve the new parenting plan. If the parents cannot agree, but the court does see a material change in circumstances, then the custody arrangements will need to be re-litigated. What about child support? Child support is determined separately from custody and visitation issues and has its own set of considerations. Factors influencing child support include the income of both parents, medical insurance and healthcare costs, work-related daycare, educational needs of the child, other child support obligations of each parent, the number of children involved, and any travel expenses. The first step in a child support case is establishing paternity. The father can sign an acknowledgement of paternity, or, if he denies being the father, the court can order a DNA test. Once paternity has been established, the judge will consider all of the factors influencing both the financial need of the custodial parent and the ability of the non-custodial parent to pay support. Once the judge rules, the child support arrangement becomes legally binding. If a parent refuses to pay child support, Their wages may be garnished, the court may terminate any professional licenses they hold, and they can be subject to arrest. What if the child support agreement needs to be modified? Like child custody, a modification of child support requires that there has been a material change in circumstances and that it has been at least a year since the original terms of support were reached. The court will also typically require that the amount of support will change by at least 20% to consider the change material. Some factors that constitute a material change in circumstances affecting child support include a change in employment status and/or income of either parent, parental relocation or remarriage, a change in the child's insurance, health care, or other costs, and medical emergencies or other unforeseen expenses. Whether you're going through divorce and determining child custody and support arrangements, or would like to seek a modification, you're going to need an experienced family law attorney. P.J. Hartman is a board-certified family law specialist with over 15 years of experience practicing family law in New Mexico. She will ensure that your interests, as well as those of your child or children, are protected. Contact us with your child custody or support questions or to set up a consultation.